And good afternoon, everyone. And I'll keep talking for just a moment here. And Rhonda, can you hear all right at this point?
Yes, Judge.
Okay. And we've got the county attorney's office. Good afternoon, Mr. Devaney. We've got standby counsel with Ms. Schmidt. Good afternoon, Ms. Schmidt. And out at the jail, we have Mr. Riggins. Good afternoon, Mr. Riggins.
Howdy. Good day.
Okay, Rhonda, we'll go ahead and go on the record. Case is entitled State of Kansas versus Wayne Riggins, Butler County case number 19 CR 502. State of Kansas appears by Butler County Attorney Darren Devaney. The defendant, Mr. Riggins, appears in person. Also appearing at this time is standby counsel Carol Schmidt. This matter comes back before the court this date for opinion ruling by Zoom hearing today. The court has taken the opportunity to review the defendant's 37 points of contention. The court has listened to approximately 5 hours of oral argument by the defendant and approximately 1 hour by the state. The court has secured standby counsel for the defendant in the event the defendant sought advice from capable, competent legal counsel. This court finds it has been the court at all stages of the proceedings herein through preliminary hearing, motions, trial, instructions, and post-trial motions. Subsequently, this court adopts the arguments and authorities advanced by the state as to all 37 issues raised by the defendant. Specifically, the court finds the defendant's recusal motion of the judge should be denied, as the court finds this judge and the defendant's grandmother have not been next door neighbors for 38 to 40 years. The court finds no conflict exists, as there is no ongoing relationship between judge and grandmother. As to the issue of the grandmother recanting her testimony, this court finds grandmother did not state her testimony was false. The court finds the trial court is in the best position and it is within its purview to view demeanor and credibility of the alleged recanting statement in its entirety. The court finds is the 81-year-old grandmother of the defendant, whom apparently she loves, and the court finds Joyce Crisp never explicitly testified she lied. The court further finds the defendant advances the misguided opinion testimony and only her testimony convicted her grandson, the defendant, herein. The court finds much more evidence was presented than just the grandmother's testimony for the fact finder to consider. As to the self-defense immunity issue, this court finds it conducted the January 6, 2021 preliminary hearing. The court found probable cause. Mr. Waggle, defense attorney, filed a motion for self self-defense immunity. Said motion was heard on 6/21/21, with the court overruling and denying the self-defense immunity motion based on the preliminary hearing testimony, Ms. Bates' testimony and Mr. Riggins' testimony, with the court finding the state had carried its burden in finding the defendant was not justified in using self-defense and therefore was not immune from prosecution. This court finds the issue was fully litigated June 2nd, 2021, and the court's finding specifically set forth at the time of the oral argument. As to the blood splatter issue, this court finds no need for specific blood splatter expert testimony. This court finds the jurors may rely on their own experience and knowledge and bring the same into the courtroom. The credibility of witnesses is for determination by the trier of fact, the jury. This court subsequently finds the state did provide full and adequate discovery upon request to defense counsel. The court finds the state complied with all discovery requirements in a timely manner and overrules the defendant's motion for a finding of prosecutorial misconduct. As to the defendant's allegation of ineffective assistance of counsel, this court relies on the case law of State of Kansas versus Pfannenstiel at 302 Kansas 747. It was the trial court's opinion that the defendant obtained very satisfactory counsel results at the defendant's trial, wherein the jury found the defendant guilty of manslaughter versus murder in the second degree, saving the defendant approximately 22.7 years in prison. It must be noted that trial counsel's performance was such that the defendant was convicted of a significantly lesser charge than the original charge. This court finds that in order to prove ineffective assistance of counsel, two steps must be proven. First, counsel's representation fell below an objective standard of reasonableness, considering all circumstances. And secondly, the court must eliminate the distorting effects of hindsight. This court finds Mr. Waggle actively and vigorously defended his client. The fact the jury did not find the defense credible does not mean Mr. Waggle did not do it. This court finds Mr. Waggle hit all the benchmarks in his representation of Mr. Riggins. Under the totality of the circumstances, this court finds this judge heard every proceeding at the times the jury was not present, and this court was able to judge the credibility of all witnesses at the preliminary hearing and self-defense immunity hearing. This court finds it can rely on its own observations. Subsequently, the court overrules all the defendant's motions and denies the relief sought by the defendant. The court does ask that Mr. Devaney prepare a journal entry memorializing the findings and order of the court this day. Court goes off the record at this time for purposes of scheduling. And I don't know about counsel, but I do have available for sentence. I believe this would be on the 26th. I think that's next Thursday. On our sentencing docket would be 1:30, January 26, 23 at 1:30. If counsel are available, I know that that's short notice. That's less than a week, I think.
Judge, I have an appointment from 1 to 2 actually that afternoon.
Okay. The next available time I have is February 23rd. February 23rd at 10 a.m.
I am free.
Okay, and Mr. Devaney, would that work?
That's fine, Your Honor.
Okay, Rhonda, does that work?
Yes, Judge.
Okay. Chris, do you see any conflict? I didn't see, I've got that morning open, it looked like.
That is available, Judge.
Okay. And I think we'll do 10 o'clock on that day. Rhonda, we are back on the record, and the record may reflect the parties or the presence of parties previously appearing. And the court does schedule sentencing herein for February 23rd, 2023 at 10 a.m. by Zoom hearing. There being nothing further to come before the court is in recess. And everyone have a good day.
And Judge, could you put your opinion ruling notes on my desk or have Chris drop them into mail to me or something like that?
Do you want them mailed to you or do you want them on your desk? Either one's fine.
We'll now take up Karis Green. Now, is Karis Green really going to be here today?
I
Have
have not heard from Miss Green, and she was ordered to show back up in Greenwood County, and I think our good friend at the sheriff's office would be telling us if she was there. So
I heard some rumor about her being picked up on local charges in Colorado. Is anyone from the sheriff's office able to tell us why Karis Green's back on the docket today? Missy, do you know officially? I don't know if you've heard anything more than just comments in passing than I have.
Yes, she's in custody. I just got off the phone with the jail and she's in custody in Colorado.
On their charges, and are they holding her on ours so that, because as I recall, the last warrant was hold without bond for us.
Yes.
that's
So
Right.
apparently when they finish their charges, she'll be either released to us or going through some kind of extradition.
I assume.
yes, Your Honor. Yeah,
So-
that's going to be from what what we'll do is she'll have to deal with extradition, and then she'll be, based on your order, she's going to be no bond until she gets back here, and then a bond will get set at that point. So I'm guessing we don't need to set anything else with me until she gets back.
I would agree. Let's just take her off the docket. I think we were a little premature getting her on the docket, but I
Okay.
think if she gets any kind of bond, she'll be gone again.